Hello, everyone. I'm your host, Andrea Weckerly, and welcome to the Ready Living Podcast, where each episode is designed to educate, inspire, and empower you to create the life you want. Thanks for joining us, and remember to subscribe for free on your favorite platform. My guest today is Sam Imperati. He is the Executive Director of ICM Resolutions, a Seattle-based national dispute resolution provider offering mediation, facilitation, decision-making, team building, and training services. He is experienced at the intersection of policy, politics, science, business, and law, and his multidisciplinary approach combines classic facilitation with the results-oriented tools of mediation to help polarized participants reach agreement both upstream and downstream. He has focused exclusively on alternative dispute resolution since 1992, managing everything from admiralty to zoning. Prior to becoming a full-time ADR professional, he represented individuals and labor unions in private practice and was Nike's assistant corporate counsel for litigation. He has taught public policy facilitation in the University of Oregon School of Law's Conflict and Dispute Resolution program, leadership, negotiation, ethics, and decision-making at Willamette University's Graduate School of Management, and environmental dispute resolution at Lewis and Clark Law School. Since 2006, he has been listed in the Best Lawyers in America for his alternative dispute resolution and mediation practice, was named the 2026 Lawyer of the Year for Mediation in Portland, Oregon, and received the Leshak Award for Excellence in Mediation from the Oregon Mediation Association and the Oregon State Bar. He is also a stand-up comedy winner. Welcome, Sam.
Hey, greetings. Thanks for having me.
What initially drew you to be a litigator, and then what shifted away from that?
My first semester of college, I thought I wanted to be a doctor, and I took Chemistry 101 and realized that I wasn't going to be a doctor and decided I wanted to be a lawyer. So I finished college, went to law school, and joined a small litigation boutique representing labor unions and their members. And I loved the ability to help those folks who were somewhat marginalized in their socioeconomic status and help them make their lives ever so slightly better. And I enjoyed the heck out of it. As time went on, I started to realize how difficult the litigation process was as a matter of time, money, and emotion. And even the winners didn't always walk away feeling fulfilled and satisfied. So I decided I wanted to become a judge. And I started off by being a pro tem or part-time judge. A third of the time, I loved sitting on the bench. I thought I was dispensing justice or helping the jury dispense justice. But a third of the time, I was so bored at the tedium and monotony and the minutia and the objections and the evidentiary rules and this, that. And the other third of the time, I was somewhat, I say with a wry smile, homicidal at the Assholian behavior of my colleagues trying to blow smoke up my robe and that of the jury. I realized that just wasn't going to be a life for me. So I became a full-time mediator. I just decided that's my career and went down to the local print shop and got business cards printed up.
I don't think anyone would accuse the United States of being litigation averse. We're often stereotyped as immediately threatening to sue someone when we're unhappy with them. And you've said that when people claim they want justice, often what they're initially seeking is revenge. The former is about righting a wrong, the latter about retaliation. Does our legal system, the American legal system, sometimes reward the revenge impulse rather than redirecting people towards something more constructive?
The short answer is yes. The longer answer is it creates the illusion that revenge and that justice will be forthcoming. But the reality is the process just eats up the litigants and spits them out. It's time-consuming, it's expensive, it's emotionally draining. You are in a battle that can go a year or two before you even get in front of the judge or jury for the final resolution. And the ultimate irony is the overwhelming majority of cases settle before they go to the judge or jury. It's just a matter of how much time, money, and emotion is going to be spent before you get to the place where you realize you just got to get this matter over with, and then a settlement is reached.
So that brings me to my next question. In a jury trial, parties hand over control of the outcome of their case to between 6 to 12 people they don't really know. Why don't more people choose a process that better protects their agency rather than going the traditional route?
I think it's a multifaceted answer. The culture, which you alluded to earlier, someone wrongs you, I'm going to lawyer up, I'm going to sue you, I'm going to get my revenge and come out on top victorious. You hit the nail right on the head when you talked about a jury of 6 to 12 people. I use this line in mediation all the time. I'm sitting down and saying, you're both intelligent, you're both business folks in a lot of circumstances, you're used to solving problems, and we're at what appears to be an impasse in the negotiations. So what's your alternative? Oh, I know. This makes sense. Let's give this to 12 people we couldn't pick out of a lineup prior to today's trial and say, we can't decide. Why don't you decide our fate and take over and just do whatever the heck, and we'll be happy with that. Really, is that how you make decisions? But people do it. And I think it's because we don't have a cultural norm of resolution. We have a cultural norm of litigation. And it's reinforced by our friends and colleagues, our advisors. Everyone is gearing up for trial. Everyone is gearing up for this illusion of a process that's going to result in justice. It's not always the case. In fact, seldom is it.
Although litigation can be an important tool when other means of resolving conflict are unsuccessful, not the least of which includes situations where perhaps not all of the parties to a dispute are willing to sit down at the table because there has to be ultimately a willingness, avoiding getting stuck in a contentious whirlpool seems like a good goal to have. And that's where alternative dispute resolution comes in. ADR encompasses the process by which disagreements are settled outside of the traditional litigation route and involves everything from negotiation, facilitation, mediation, and arbitration. Can you give us a quick overview?
Sure. There's a spectrum. We start with my preference and how I coach people who find themselves in conflict is face-to-face negotiations. Sit down with your loyal opposition, explore the dynamics, look at the possibilities rationally, and see if you can come up with a solution that works for everyone. If that doesn't work, then the next step is facilitation. And facilitation is bringing in a neutral third party who can facilitate the conversation. There's a thin and wavering line between facilitation and mediation. Mediators are facilitators. Like facilitators, they're neutral third parties. The big difference is that we have confidentiality in most statutes in most states that allow the conversations to be off the record. So the parties can be more candid than they would be if it was in a facilitation process where there was no confidentiality. Assuming the neutral third party can't assist the parties in getting to yes in a mediation process, then there are other interim processes like ENE, early neutral evaluation. The parties and or their lawyers could say, hey, we need someone who has subject matter expertise. Maybe it's in the law, maybe it's in the technology, maybe it's in the specific subject matter where it's very, very technical in nature. And we want to get kind of a quick peek as to what a neutral might think of the particular fuss we're involved in. Maybe the law is unsettled and you get a law professor, former judges to look in, and the parties will brief that neutral, and that neutral then gives an opinion, a prediction as to what the law may well be. That can be binding or advisory. Most people pick advisory. They want a quick peek. They don't want to have that opinion come back to bite them if they don't like the result or disagree with the results. So they make it advisory, and it doesn't see the light of day beyond the two parties that are involved in the fuss. If that doesn't work, oftentimes arbitration is the next step. But what's arbitration? Well, it's really trial to a judge. But the judge is a private party, a private person, and not wearing a black robe. An arbitrator really is a person that the parties will pick. And the beauty of that is, as opposed to getting 12 people who aren't subject matter experts that don't know anything about the case, The parties and their lawyers can select Joe or Susan who are in the local community and know this area of the law and or know this subject matter inside out, upside down. And that increases the chances that there'll be a result within the range of reason. As opposed to giving it to a jury, they could go and get the matter radically wrong, either for the plaintiff's benefit or from the defense benefit. And then obviously the final step would be going into the court process, the trial, and then the appeals.
You were talking about arbitration and using a judge as an arbiter, for example, but very often what we find is that corporations are writing mandatory binding arbitration clauses into consumer and employment agreements that in effect strip people of their legal rights.
Well, I was a baby lawyer. There wasn't mediation and arbitration as the alternatives. Well, all of a sudden came along this thing called arbitration, this less formal opportunity to have your day in court, but it was private and off the record. So you had the confidentiality and didn't have to worry about airing your dirty laundry in the court of public opinion. And it was touted as being less formal, therefore less expensive, quicker time to resolution, and you would get a subject matter expert who would make the decision. And that was touted as the future coming, the panacea of dispute resolution. Well, guess what? After 5 to 10 years, arbitration became just as expensive, just as time consuming, as fraught with peril as going through litigation. There are restraints on arbitration. Oftentimes you can't appeal it. The arbitration award is final and binding, absent some very rare circumstances, unlike a jury trial or trial to a judge. What do big companies fear? They fear public exposure of their dirty laundry, and they fear runaway juries. I believe in the jury system. It works the overwhelming majority of the time. But what companies want is to resolve these disputes and minimize their transaction costs and minimize their public exposure. It could be abusive, these mandatory arbitration clauses, because oftentimes when people sign this contract waiving their rights, they're waiving things like punitive damages and the right to set a precedent and the right to let society know that this bad actor engaged in this thing, and it allows less than optimal behavior to slip under the radar. Yes, it's more efficient, but is it really doing justice as defined by everyone, not just the person who is writing up these contracts? Don't you love when you get a new software licensing agreement? And of course, up comes the screen. You scroll down, half of it's in Latin. It goes on and on and on. But you can bypass all of that by just checking a box that says, I agree. And boom, you've agreed to waive your rights to a jury trial, waive your right to publicly put forward what sins you've had to endure at the hands of somebody else. And, most people don't find that fair and reasonable. It feels like a trick has been played on them.
On LinkedIn, you wrote that unresolved conflict costs organizations something in the neighborhood of $250,000 a year, and that's before accounting for turnover, legal fees, and lost innovation. Most leaders treat conflict as a people problem, but you say it's a business problem.
The people that are employed in companies are really the capital of the company. They are the assets of the company. Without them, a business isn't going to be able to survive and thrive. When people are unhappy, they're stressed out, everything they do, say, don't say is being questioned. They feel marginalized and feel like they're just a cog in this wheel, and they check out. Lost productivity rears its ugly head because they're not motivated. They're saying, I've got 10 years, 6 months, 3 weeks, 2 days, and 17 hours until retirement. And I'm just going through the motion. And then the related problem is coworkers turn on each other. Different departments turn on each other. There's conflicting KPIs, critical performance indicators. And we start arguing over everything out of our own self-interest as opposed to the common good. And all that time and energy and creativity is sucked up managing the yuck as opposed to proactively moving forward in a collaborative fashion.
You've argued that the smartest thing two parties can do when they're writing a contract is deciding in advance how they'll resolve disputes if things go wrong.
No one anticipates the inevitable yuck that challenges every human relationship. So they don't spend the time to think ahead to the possibility, in some cases, probability, given the failure of small businesses, that things may go south. Well, the best time to create an architecture for ending the relationship is in that honeymoon phase where you care about the other person. You want the result to be fair. You want the result to be open and transparent. You want it to be efficient. You want it to be respectful. All the values, the positive values are aligning during that honeymoon period. If you don't do that, and then of course we default to, I'll see you in court, blah, 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 blah.
So let's get into some of the hands-on details now. How does a trained mediator help parties in negotiations or dispute situations? What does a professional like you do for parties that they can't do for themselves?
I think just as a matter of just human nature, it's harder to engage in jerk-like behavior with a third party in the room than it is if that third party is not in the room. When the parties are unassisted in their approach, they let down their guard and they get in touch with their inner jerk and they indulge those little inner demons and engage in behavior that's unlikely to get to yes. That gets dissipated and mitigated because people don't want to show their core jerk to a third party who has no stake in the outcome, especially if they believe that third person is going to be judging their credibility, judging the viability of their arguments, and making suggestions that they hope are in their favor. They want to present themselves as, I am the reasonable one. And you will side with me because only a reasonable view of the world is consistent with how I see things. And so what we do by just being in the room is we change the dynamics from literally a dyad, party A versus party B, to a triad where the parties now are looking to the third party neutral for guidance on the process. Depending on what kind of mediator you are, that guidance can be just on the process and help them have a difficult conversation if they are on what we call the facilitated end of the mediation continuum, or to help them brainstorm options for substantive resolution. And that happens if the mediator's on the evaluative end of the continuum. So we assist parties having these difficult conversations, both with process and substance, depending on what they want.
People sometimes use the words settlement and resolution interchangeably, but you've said that there's a distinction.
The story I tell, and I emphasize the word story, is that when you go to judge school, you learn that a good, quote, settlement, unquote, is when everyone walks away equally unhappy. When you go to mediator school, you'll learn that a settlement is not enough and not what the parties usually want. They need something richer and more satisfying and more durable, and we call that a resolution. A resolution is when both sides walk away with their underlying business and personal needs reasonably satisfied. The process is more exploratory, it's more respectful, it's more problem-oriented. When we're in conflict, we have a choice. You can build a case and fix blame, or you can build a relationship and fix the problem. If your goal is to build a case and fix blame, the most you're going to get is a settlement where everyone walks away equally and happy as the best case scenario. If your goal is to build a relationship and fix the problem, you can do better than a settlement. You can get that richer and more durable resolution and walk away with your underlying business and personal needs reasonably satisfied. And one of the collateral benefits to a resolution versus a settlement is the compliance rates of a resolution are much higher. There is a difference when it comes to compliance with the deal. When you have a settlement and people walk away unhappy, They are reluctant to comply with the agreements they made because they didn't think the process and the outcome was fair. When parties reach a resolution, they say to themselves, wow, that was better than I anticipated. It really was an exploration. The process was respectful. The outcome was fair. You know what? I'm not going to make the other side take me to court to enforce it or go through a bunch of hoops to make sure I do what I said I was going to do. So it is a more successful process in the long run.
In your work, you talk about the tension in every dispute between logic and emotion. How do you hold both of these at the same time?
Especially when we are in conflict, we humans spin in the intersection of logic and emotion. It's a roundabout. One is the voice of logic, and the other is the voice of emotion. And they're whispering into our heads simultaneously, do this, don't do that. Oh, you should react. Oh, that's not fair. All these conflicting little voices. So we have this internal dialogue that we are trying to manage. Do I listen to the logical voice or do I listen to the emotional voice? And it's very, very challenging. Even as a trained mediator, I find myself still being reactive if I think unfairness is rearing its ugly head. I try to say, time out. And then I say, what's your goal? Is it to build the case and fix blame? Or are you here to build a relationship and fix the problem? Can't do both. Once I make that binary choice as to my goal, the reactivity increases if I'm building a case and decreases if I'm building a relationship.
Not that long ago on LinkedIn, you shared the Integrated Conflict Management Pocket Handbook, where you talked about the importance of validating, empathizing, clarifying, and summarizing. Can you give us examples of these, and what does it exactly sound like to validate someone you disagree with? Because I imagine that is so hard to do.
It can be challenging, especially if the emotional voice on your right shoulder is whispering sweet nothings into your ear that are better left ignored. That technique, validate, empathize, clarify, and summarize, VEX for shorthand. The mantra is when they vent, we vex. So when the person with whom you are interacting is venting, instead of reacting and venting back, we instead say, time out. I'm not going to do that. I'm going to maintain rationality. I am going to vex them. Step one is validate. It looks like this. You are giving me a piece of your mind. I appreciate you telling to me directly. Most people just talk smack behind my back. I appreciate the opportunity to explore this with you directly as opposed to guessing and making assumptions about what you're thinking and feeling. The V, the validation, is acknowledging their directness. And really, it's a gift because so many people are passive aggressive and you have to guess what's going on. They don't tell you, they ghost you, whatever the case may be. You're basically thanking them for speaking, even if you disagree with their message. The second step is the E, empathize. So how do you empathize? You will say something like, that's tough. That's frustrating. I can't imagine how that makes you feel. Tell me more about that. Help me understand how that impacts you. You're asking questions that allow the recipient of the vexing to explain and explore and get current with you. So validate, empathize. That's the traffic on the emotional street, the V and the E. The traffic on the logical street is the C and the S, the clarify and summarize. So how do I transition? I will say something like, there's a lot to unpack here and process. I am going to try to summarize what I'm hearing to make sure I haven't added an unfounded assumption that you are not saying. You are upset with me because of A, B, and C. You had wished I had done D, E, and F. What am I missing in my analysis of your concerns? What am I not hearing? And then once I do that, validate, emphasize, clarify, and summarize, I might say, where should we go from here? I will ask them, what do they want to do next? What they want to explore next? What we tend to do is react fire with fire. I'm suggesting it works better if they talk 90% of the time in the first portion of your dialogue. You are inviting them into an exploration because you're there to listen, not just respond. So validate, empathize, clarify, and summarize. It works.
You've also written about something called the WOWD factor, WOW factor.
WOW factor. It's an acronym. Way out with dignity. People are more likely to say yes to a deal if you give them a way out with dignity. If you force them to lose face and give you what you want, they're less likely to do it. So just as a tactical matter, you're more likely to get a result that works for you if the person you are getting a concession from can preserve their self-image and self-identity than if you beat them down and they're looking up at you and saying, please have mercy on my pathetic soul. They're not going to do that unless they have no other choice. So that's the wow factor. Give everyone a way out with dignity.
One of the interesting things you mention in your work is shadow juries and negotiation. How does that invisible audience change what happens at the table, and how do you account for that?
So as a mediator, we always want the actual decision maker, the deal maker or the deal breaker, to be in the room present, to totally understand the ebb and flow, the nuances and the subtleties that happen in the negotiation that make whatever deal make sense or have it become nonsense. Most companies will send a representative. They'll, of course, have a lawyer, but they'll have a representative, a director, a vice president, what have you. That person will have, in all likelihood, limited authority. They will have been told the day before by the CEO or the chairman of the board or whatever the power dynamic structure is. You can settle within the following parameters and you shall not deviate from them. So they have limited authority. Voices are playing out in that negotiator's head. The voice that's present in the room, them, their lawyer, perhaps the mediator, raising arguments that the CEO never thought about. There are new facts here and new circumstances here that we didn't consider. Now we're getting this mediator, neutral third party, giving a perspective that isn't as rosy as we thought it might be. I am reluctant to continue to negotiate and make any more concessions because my fear is my shadow jury. The CEO says, are you kidding me? You exceeded my authority. When was your last clear thought? And that's the shadow jury. And that's why us mediators want the ultimate decision maker in the room to avoid this dynamic.
So let's assume you do have decision makers in the room at the table. And I know we're speaking very, very broadly here, but sometimes there are power imbalances between parties. Is mediation appropriate when one party has significantly more financial resources? What about in the interpersonal realm, divorce or custody situations involving abuse?
This is a very hot topic in mediation land. We have ethical codes, just like every other profession has, usually called mediator standards of conduct. And one of the codes talks about impartiality or impartial regard, that mediator's job is to not favor one team over the other team. Mediators are human beings and we have points of view and we have different value systems and different priorities. And it's very, very difficult, in some cases impossible, to check those values and points of view at the door. We cannot act on those impulses. Our job is to treat each party independently and fairly and separately. Some commentators in the field say we can't be impartial. Maybe we should be omni-partial. We should treat everyone as though we care about them deeply and fairly and equally. That only goes so far. You have raised a couple of issues that we call power imbalances. when party A has more power than party B. That can come in the form of physical size, that can come in verbal acuity, that can come in the size of the pocketbook, it could be raw intelligence. It is the mediator's job to ensure that the parties at the table have a full, complete, and fair opportunity to be heard. Where the internal mediation land controversy comes into play is balancing a substantive imbalance. Let's say you have grandma versus the big, bad, and ugly corporation in mediation. There is a power imbalance there that is obvious. It is unclear to me how one can maintain impartiality and simultaneously help grandma because grandma doesn't have the resources of the stereotypical big, bad, and ugly corporation or company or organization or political party or whatever the group might be. Because the reality is, when that mediation ends, that pre-existing power dynamic still exists. So you have the abusive spouse problem. The mediator can help in that moment. But the reality is, when the mediation is over, that underlying dynamic is still going to exist. And if the mediator puts their thumb on the scale and helps the victim, the perpetrator is going to feel that they were treated unfairly and seek revenge when the mediator is not in the room. So you can set up this dynamic where you can make matters worse by rectifying substantive power imbalances, which then leads to your point that maybe mediation is not the appropriate forum. Maybe say, I am dealing with a narcissist. Mediation is not going to fix this dynamic. Even if a deal is reached, it will be breached. We're not going to mediate this. We have got to go to court and have a judgment and judicial and legal enforceability. Mediation is not appropriate.
There's also something called concession aversion. Why do people sometimes reject deals that would leave them better off than no deal at all?
It's because you suggested it. And that's why I'm rejecting it, because I'm in a death spiral fight with you. And related to that, it's hard for people to give up something they have than forgo something they don't have. Meaning, if you're asking me to give you $100, my net worth goes down $100 or yours goes up $100. But if you're saying to me, I'm not willing to give you $200, I'm willing to give you $100, it's easier for me to say yes to that loss of $100 because I didn't have it in the first place. Cognitive biases, to me, are absolutely indispensable learning that people need to engage in to really help them navigate that intersection of logic and emotion.
That brings us to the greater topic of emotional intelligence. Not just focusing outwards, but also doing the best we can to know who we are. The more that we know, for example, our own biases, our own trigger points, our own tendencies to react a certain way, the more we can become conscious about that and decide whether those are appropriate given what the situation is.
My self-talk and my goal is to simply say, I know what I'm feeling right now. That doesn't mean I'm entitled to indulge that feeling and act on that feeling just to make myself feel good in the moment. I feel this way. I'm human. Doesn't mean I get to act with impunity based on that feeling. And the more you have knowledge about these cognitive biases and EQ, the more likely you are to modulate and moderate that reactivity.
To successfully resolve a dispute, being able to rely on what the other party is saying is critical, but there are situations where it's not clear if they're telling the truth. How can you tell if somebody is trying to spin you?
There are certain patterns and behaviors, and of course, nonverbal communication studies talk about various clues and hints and nonverbals that give us hints that someone may be, let's just say, unfamiliar with the facts as they're commonly understood. For me, it's in my gut. There is some dissonance there in the presentation, in the words, and comparing them to past behavior, or just as a matter of intellect. I take people at face value until they prove me wrong. You're not going to be able to always know if you can trust what your loyal opposition is telling you. But there are contractual provisions and techniques that you can use to increase the chances of not getting burned by that. So you put in representations and warranties in the deal. You would say, we're going to agree to do A, B, and C because you have represented the following facts and circumstances, 1 through 10. Our deal is predicated on the truthfulness of those 10 warranties or representations. If they turn out to be wrong or inaccurate, this deal is off and we're back to whatever remedy you have negotiated going forward.
What about paltering, namely using technically true statements to mislead? In other words, not lies, just carefully chosen facts arranged to steer someone toward the wrong conclusion. This shows up in negotiations and advertising, in politics. Oh my goodness. How do you spot it and how do you call it out without blowing up the conversation?
I tend to say things like, that's an interesting story. What have you left out? What are you not telling me? What would be the advantages and disadvantages of your proposal? Of course, they'll come up only with the advantages of their proposal. Then I'll keep pushing. Well, what would be the disadvantages? What would someone think about your proposal if they were on the other side? What happens if your factual assumptions don't pan out? It's basically the art of the question. I think you're not going to get anywhere by simply saying, liar, liar, you're trying to manipulate me. You have to ask questions.
So, what do you do when a negotiation or a mediation seems to be going off the rails? For example, someone's yelling, someone's shutting down, or someone walked out.
It happens. At the beginning of the mediation, I'll have everyone in the room and I'll talk about my background, my impartiality. I'll talk about mediation confidentiality. I'll describe the process. This is a joint session. We're all in the same room. I may break us up into separate rooms. We're called caucuses and do shuttle diplomacy back and forth. And then I'll say there's a certain rhythm to the mediation process. In my experience, each of you is going to want to leave 3 times before this matter is done. Each of you are going to believe that we've reached an impasse, that this is an exercise in futility and a waste of time. That is a normal part of this process. Mediation is voluntary. You're free to leave at any time. I simply ask you the professional courtesy to sit down with me before you make the final decision to leave and see if we can explore ways to change this process and dynamic to make it worth your while. So by predicting that which is likely to happen, when it happens, it takes the sting out of the emotionality of apparent impasse. And it makes it easier to continue the hard work, which is a resolution versus a settlement.
People walk into conflict with different default conflict styles. Can you share with us what the main ones are?
At the end of the continuum are avoidant and aggressive. On the aggressive end of the spectrum, you walk into a room and the muzak that's played is from the theme from Rocky. Everything is an argument. Everything is a fight. There has to be a winner and there has to be a loser. The other end of the continuum is the avoidance style. It's the personality type where you need the jaws of life to get information out of the person. And then in between, collaborative, compromising. I do this exercise with parties in more of the facilitation setting than in the mediation setting. I draw a continuum on the whiteboard, 1 to 7. 1 is avoidant and 7 is aggressive. Right smack in the middle is compromising. And I say, all right, here's what we're going to do. Everyone, write down the number on that continuum as to where you are in your default conflict resolution mode. Now I want you to think of your loyal opposition. What number are they at? I am so reasonable and balanced and moderate in my approach to conflict, but they are on the lunatic fringes of sanity. They are so aggressive or so avoidant. It's amazing they get through their world given the dysfunctionality that is them. So we exaggerate the downsides of the other's approach. Is so human of us.
I know from experience that someone's conflict style can be situational, different in different settings, or depending on what the circumstances are. How do you build that into your analysis of where the parties are in terms of their conflict style when you're mediating them?
It leaks out. And I'll tell you how it leaks out. Related to conflict style, avoidant, aggressive, points in between, is risk tolerance and risk aversity. I find people avoid conflict because they're trying to preserve the status quo, even if that status quo is dysfunctional and not serving them well. People who are conflict tolerant don't mind the status quo being changed because they are comfortable with whatever risk outcome comes their way. What happens is people will say little hints, they'll make an aggressive statement, and then they'll say, my gosh, what if they don't say yes to that? The second thought that they utter is their default core approach. They'll act out on the opposite end of their continuum because they think situationally that's what the fuss requires. But that other little voice, their home voice, just spurts out. So I always listen for the second statement.
After more than 3 decades of this work, what's the conflict you see people make most often and most unnecessarily?
I don't think it's a topic-specific answer as much as it is an emotional intelligence answer. I think it's indulging those inner voices. If we allow those inner demons to take control and indulge that negativity, the end result is almost always worse than it needs to be. I've seen an increased polarization. It's quite evident. The question then becomes, what are we going to do about it? And I think what we have to do about it is start recognizing that we're all in this together and we have more in common than not. And that's what mediators do. We focus on what the parties have in common first. You got to start with commonality.
Where can people find you online to learn more about your work?
I have a website. It's www.icmresolutions.com, www.icmresolutions.com. It has a bunch of free resources, a toolbox. There's also an assessment, internal conflict assessment.
Sam, thank you so much for having taken the time today.
Oh, well, thank you. Congratulations on doing great work.